Robert Swain, petitioner versus Alabama. Senator Motley.
Mr. Chief Justice, and may it please the Court. Petitioner, in this case, is a Negro male about 20 years of age, and he asks this Court to review the judgment of the Supreme Court of Alabama, which affirmed his conviction and sentenced to death on a charge of rape. The petitioner was convicted of raping a 17-year-old white girl and was sentenced to death by a petty jury sitting in Talladega County, Alabama. No Negro has ever served on a petty jury in Talladega County because they are always struck from the trial jury venire by the state's attorney.
Senator Motley, in Alabama, does the jury assess the penalty in a case of this kind?
Yes.
Within what range?
Well, no.
They obviously can impose the death penalty.
Yes, they did in this case assess the penalty of death. That's the penalty in Alabama.
It is in their discretion, fairly wide discretion, the penalty.
It's life or death, I understand. Petitioner claimed below, of course, and asserts here that his conviction violates the Equal Protection Clause of the 14th Amendment in that the grand jury which indicted him and the petty jury which tried, convicted, and sentenced him were the products of racial discrimination. Now, in a capital case in this county, the circuit judge orders the sheriff to summon at least 50 and not more than 100 persons to serve on the petty jury. About 75 usually appear if 100 are summoned. And of this number, there will be some who claim exemptions and others will be excused for various reasons. And then of the number left, say there are 50 left, the striking then begins in this fashion. The state strikes one and the defendant strikes two. Yes, that's right. That's right, yes. That's right, sir, yes. Yes, at the early stage, the counsel... That's right, yes. The counsel can challenge for cause. Others will come in and claim exemption of those called to serve. And after all of those exemptions are claimed and all of the challenges for cause, then you begin to strike from those that are left. And it's usually, as I say, 50, maybe 75, and you strike down until you get 12, and these 12 constitute the jury. Yes, that's right. That's right. The last 12 serve on the jury. Pardon me? Well, it depends on the number left, you say. You don't have a set number. That's right. It varies depending upon the number left of jurors after all exemptions and challenges for cause. Maybe 40 left or 50. The prosecutor strikes one, the defendant strikes two, alternating, until there are 12 left. So it will vary from case to case. Well, there is a provision that if the defendant doesn't strike, the judge must strike for him in the Alabama law.
What I had in mind was both the prosecution and defense counsel. They have 12 in the box, and while there's still 20 or 30 on the list, neither wants to strike anymore. May that happen?
Oh, I guess you can accept the box, yes, of the 12, yes.
They have a special panel summoned for capital cases.
Well, what they do is to summon additional jurors in addition to those who are summoned for the week. And this may not exceed 100 in number. And, of course, if they run out, they always summon additional jurors to serve.
Well, the statute formerly provided that they were compelled to have a special panel. Is that still the law there?
Well, yes, I think so. I think what happens is that this extra number that are called, in addition to those that are there for the regular trial for the week, or who have already been called, is what they refer to as a special venira for a capital case, because they usually do not have as many as 100 there for the trial of a case for that week.
What happens if 12 jurors seated opposing state strikes?
Well, then they would have... You mean if they have... I don't...
Agreed, they've gone through this process. They've seated 11 jurors, and 12 comes on the state's hearing challenges the 12th juror in one seat. What happens further for it?
you're saying there are no more jurors left to strike from? I don't...
There are 11 seated.
Yes. Yes.
12 men comes on the state
It doesn't work that way. There's
No.
You begin with 30 or 40.
That's
And
right.
then you reduce it to 12.
That's right.
On a 1 to 2 basis.
Yes. I didn't understand your question, Your Honor. I thought I had explained it, but I will say it again. Between 50 and 100 are called to serve. Some will claim exemption because they're over 65 or under 21. Certain occupations are exempt. Then others will be challenged for cause, reducing the number available for actual service to maybe 40 or 50. Then the striking begins. The state strikes 1, the defendant strikes 2, until only 12 remain. Those 12 constitute the jury for the trial of a capital case. That's right, yes. That's right.
Interrogation of the jurors by counsel or by the court?
But by both.
Uh-huh.
By both.
Prior to this
Yes.
peremptory strike.
That's right. Yes.
Individually?
Yes, the defendant can inquire, and the state may inquire and examine the jurors, and I understand the court can excuse anyone that the court feels is not qualified to serve. Now, the Supreme Court of Alabama found that there are usually Negroes on the venire. Negroes are usually in the jury box and called, but the Negroes are always stricken. And no Negro has ever served on a petty jury in that county. And the Supreme Court of Alabama held that the fact that the prosecution peremptorily strikes every Negro from the jury panel in a case where the defendant is a Negro does not constitute a violation of the defendant's constitutional rights of due process or equal protection of the law. Clearly established... Pardon me?
You attacked only the petty jury, or you attacked the grand jury also?
We attack the grand jury also. We say that that's our second point here, and that is that the grand jury and the petty jury are drawn from the same box. But what you have here is few Negroes in that box because the jury commissioners have not carried out their constitutional duty to fairly acquaint themselves with all qualified jurors in the county. They have a very haphazard method of getting names in that box, which favors a larger proportion of whites, and qualified Negroes are obviously not put in the box. So you have a small number to start with. Now, as I said, this record clearly established that in every case, Negroes are struck from the venire, and the prosecutor or the solicitor's own testimony is that whenever he has a case, he goes over to the lawyer on the other side and he says, look, we have some Negroes here. Do you want to use Negroes? And if the defense counsel says no, and he invariably does, and if the solicitor doesn't want to use them, as he says, we strike them first. In other words, we get rid of Negroes as Negroes. Now, the prosecutor never struck any Negro because he felt that a particular Negro had a bias against the defendant or the state. He never struck any Negro because he felt that a particular Negro or several Negroes on that Banara would not afford a fair and impartial administration of justice. His only consideration...
Those reasons would all be for cause, I suppose, if you could show.
Yes,
but we're talking now about peremptory challenges, and the very word peremptory, as well as the history of peremptory challenges, indicates I had thought that the person could be as capricious, whimsical, arbitrary, or prejudiced as he wanted to be.
Yes.
In challenging George.
But there are some instances where the solicitor cannot prove bias, you see. And if he attempts to prove in a case that a particular Negro might be biased in favor of the defendant because he's Negro and fails, he may then challenge that Negro peremptorily. And that's not because of the Negro's race. He's then using the peremptory challenge in the manner in which it was intended. And that is to eliminate bias which you could not prove, on which you merely have a suspicion or a whim, and you get rid of the Negro that way. But
you always could use the peremptory challenges that way. If I didn't like the fellow's tie, color of his eyes, I thought maybe he looked at me sort of askance, I wouldn't strike him. If I had a challenge left, of course, in my jurisdiction, we had 6 challenges. We didn't have unlimited challenges. They do in Alabama. But do you mean to say here that the lawyer, before you can use a peremptory challenge, must show grounds like bias?
No, I think that it is not absolute in that sense. That was never the original purpose of the challenge. Its purpose was to secure an impartial jury and to provide for the elimination of bias. And it wasn't, I guess it is used in the manner which you suggest, wholly arbitrarily. But I don't think that that was the original intention of it. I think it's always been limited by the necessity of a fair and impartial jury for the defendant and the public's interest in the impartial administration of justice. So that in every case, I would think that that we would have the burden, of course, of establishing that race was the motive, and it may be difficult in some cases. But the peremptory challenge, we say, cannot be used to, in effect, defeat the decisions of this court construing the Equal Protection Clause, or to violate the federal statute which says that no state officer may exclude Negroes from the jury on account of race. And that... Well, again, the question would be whether the challenges have been used to discriminate against a whole racial group in the community. If he struck Negroes because he had to use 6 challenges, but whenever he always struck Negroes, we might be able to prove that even in such a case, the prosecutor's motive was racial discrimination. Well, our position is that the prosecutor here had a policy of excluding Negroes. He did it through the use of peremptory strikes. He says so. He says, I always strike Negroes. I go over and I talk to the other side, and we come to an agreement, and we take the Negroes off. And this record shows that his use of the strikes was to effect racial discrimination. This court has ruled that they cannot exclude Negroes from the grand jury panel or the veneer, and it shows that they made some attempt here to put some Negroes on. But he used this to effect racial discrimination. And our point is that any state prosecutor who uses his peremptory challenges to effect this result, exclusion of a whole racial group, violates the Equal Protection Clause. Oh, yes. Yes, that's our second point, as I pointed out before, that the striking is facilitated by the fact that the jury is originally composed, that is, the box, was a result of racial discrimination. I think the record is clear here that Negroes were about 26% of the males in that county over 21. In other words, 26% Negroes were potentially qualified, but the largest percent that had ever appeared on a grand jury panel or petty jury panel was 10, 12, or 15%.
Other qualifications in addition
that's
to
right.
21.
That's right. But we said, what I'm saying is that there were 26% potentially qualified. We put on testimony to show there were other qualified Negroes. I think about 13 Negroes, out of which 12 were qualified, met all the other qualifications. And the one jury commissioner even admitted that there were probably Negroes qualified who were not in there, because he had made no effort to ascertain all qualified persons, and the statute certainly required that. So that it's clear by their own admission that there were Negroes outside of this box who were not qualified. And this small number of qualified Negroes being put in the box facilitated the striking when it came to that. So you can tie these two things together, of course, and show that this is clearly a case where you have a state policy of excluding Negroes from their proper participation in the administration of justice and participation in the jury system.
There are only men jurors in Alabama.
That's right. They exclude women.
Senator, may I ask you this question, please? I don't know that I quite have your point yet. But assume that this jury was impaneled legally in all respects, and they came to the courtroom, and the prosecutor used his challenges, his peremptory challenges, for the purpose of eliminating Negroes from the jury. Do you then say that that is state action and that,
yes,
that's discrimination and this case should be reversed?
Yes. If the prosecutor always strikes Negroes, if race is the criterion, and we show that he always strikes Negroes, and no Negro ever serves because of his policy of striking all Negroes, that would violate the Equal Protection Clause. Well, the state cannot use its peremptory challenge to exclude Negroes solely because they're Negroes. Because then the state is using a racial criterion for selecting the members of the jury.
Suppose your argument goes farther than that. If the state allows any peremptory challenges at all, then you have to assume that some people are going to be prejudiced against Negroes. Some lawyers or their clients are not going to want Negroes on their jury, for a very prejudicial, capricious, and arbitrary reason, and that the state, therefore, is authorizing that to be done, whether it be by the prosecutor or by defense counsel or in a civil case.
That's right, yes, because this jury selection is an important part of the administration of justice. It's an integral part of the system of justice. And we're saying that race cannot play any part in the administration of justice or the jury selection process. Yes, I say, even in the case of the defendant, I don't think that race can be allowed as a criterion even by the defendant, because
what if the defendant, though, thinks that, say there's a Negro defendant and thinks that a Negro would be, just because he's a Negro, would be biased against a Negro defendant? I mean, it's not just that, the fact that he's a Negro means bias to him.
Yes.
Isn't that a little bit different?
Yes, that's different, because he's eliminating him for bias,
right.
which
now,
he
let's
suspects.
say the prosecutor eliminates a juror because he's a Negro, only because he's a Negro, but only because he thinks that this particular Negro might be biased.
That's right. He can use his peremptory challenge to eliminate a Negro that he suspects of bias.
All right, but it's the only reason he suspects him is because he's a Negro.
Well, I think there would be cases where that would arise out of the facts in the case.
He certainly does in the defendant's case, doesn't he?
No. In the defendant's case, he had no reason other than race. He wasn't suspecting bias. He wasn't eliminating Negroes as a part of his trial strategy or anything like that.
I know, but in the case of a defendant exercising his peremptory challenges, when he says, the reason I'm going to strike this Negro is just because he's a Negro. Because I think he'll be biased. But the only reason I think he'll be biased is because he's a Negro.
Well, what he suspects is definite bias, I would think, with respect to himself. He may be white, and he says, well, I don't want a Negro on my jury because I am charged with burning down a Negro's house. And this Negro may be biased against me. So I'm going to get him off the jury. Now, he's suspecting a definite bias. He may not be able to prove it because he puts the Negro on and questions him and he denies it. He says, I can fairly decide this
case.
But
your point is, on the prosecutor's side, exercising these peremptory challenges is that it may be that you couldn't successfully challenge every peremptory challenge that a prosecutor made just because the fellow was a Negro.
That's right.
You may not be able to do that, but it's certainly true, you say, that every Negro on every jury for years and years shouldn't be challenged because he's a Negro.
That's right. From that kind of pattern, we can infer that racial discrimination was his motive.
Well,
and there's a case where he admits it, as here.
Why does how come the prosecutor gets this kind of an answer when he asks the defense counsel, do you want Negroes on the panel? And is this true that the defense counsel answers, no, I don't want Negroes on the panel?
That's what he said. That's his testimony on page 20 and 27 of the record. He says, they always say, no, I go...
So he never got any different answer.
That's right. He said the only variation was once he had a Negro accused of murdering another Negro, and he wanted to vary this pattern by offering him an all-Negro jury. In other words, he always took up race as a primary consideration with respect to the composition of every jury.
Well, now, do you have are there any figures or any evidence in this record as to how many times or what part of the Negroes who were thrown off by the defense over the years?
No, it doesn't indicate that precisely.
I assume there some have been.
That's right.
How about in this case?
And in this particular...
Were all the Negroes eliminated from the panel?
by the solicitor. You see, in the instant case, there was a veneer of 100, that's a stipulation, 8 Negroes. 6 were available. The prosecutor struck all 6.
So he had to do it 3 times. He got 2 off first?
I don't know exactly how he got them off, but he was with his 6 strikes. He had one at a time.
None of them was eliminated by the defense.
That's right. No, that's right. And this was a practice in civil cases also. There were lawyers who testified that in every civil case they did this too. So it was a general community pattern here.
Was this question asked in this case of defense counsel? Do you want any Negroes on the jury?
I don't believe so. I'd like
do you have to go as far as you do to prevail in this case? Do you have to go as far as you have just gone in making this particular argument in order to prevail?
Well, I don't understand. As far as I've gone, I don't...
Well, what I mean is this. Do you have to premise this entirely upon the use of peremptory challenges by the prosecution in order to win this case?
We can win on the second point, which is that the organization of the grand jury and petty jury from the start were the products of racial discrimination.
Well, we've heard very little about that.
Yes. Well, we have it in our brief. I referred to it that what happened here was that the jury commissioners had a very haphazard method which favored whites. As a result, very few Negroes actually got in that box. I'd like to save the 3 minutes I have for rebuttal.
Mr. Hall?
Mr. Chief Justice, members of the court, I'm quite surprised that Mrs. Motley didn't go into the other question. She saved 3 minutes for that. I'm also surprised that she spent so much time on this particular thing, because it's been pointed out time and time again by various courts throughout the country, including a court from Mr. Justice Clark's own state, that the matter of peremptory challenges is a matter that is reserved exclusively for counsel on each side. They don't have to assign any reason. Counsel does not have to say why he's challenging a person when he's exercising his peremptory challenge. He may not, as one of the justices pointed out, may not like the color of the tie that the person is wearing. He may not like the color of the shirt he's wearing. He may not like the color of his eyes. It reminds me of a case that I was retained on back in 1936 when I first started practicing law down in Baldwin County, Alabama. There was a lawyer over in Mobile by the name of Henry Aldridge who was not too well acquainted with the residents in Baldwin County. And that particular case involved an ejectment of a squatter who had decided he was going to take over a piece of land down there in the swamps up above in the Tensas River, up above the causeway, and it goes over to Mobile. Being a native of Baldwin County, Henry Aldridge, who was one of my classmates, asked me if I would associate with him for the purpose of striking the jury. And that was the only reason that I was hired in that particular case, was to strike the jury. My purpose in that case was to strike off tenant farmers, renters, sharecroppers, and any other person that had no interest in owning property. When we got through striking the jury, we wound up with a jury of all landowners. The case was tried for 3 days. At the end of the trial of the case, we won the case. We did not have to assign a reason why we struck anybody off that jury. There's no reason in the world why I have to assign, when I'm prosecuting a case or defending a case, why I'm striking a Negro, why I'm striking a Mexican, why I'm striking a Chinaman or anybody else off that jury, as long as I'm exercising my peremptory challenge. Now, of course, when I get down to the point of striking for cause, then I have to have a good reason. And I think all the members of the court know that. I think all the members of the court have tried cases from time to time. But, as Judge Grooms pointed out in a class action that was brought down there in Birmingham 2.5 years ago, and was tried with reference
to Jefferson County in particular, and then later on back in October, and I was in that case, with regard to the Bessemer Call. Judge Grooms, in a decision just handed down the other day, on the 2nd of December, said, the number of peremptory challenges in both civil and criminal cases is fixed by statute. The exercise of such peremptory challenges rests exclusively with the parties.
May I ask you, if you would mind telling us first, do you have a special law in Talladega County with reference to capital cases and how many jurors you'll draw, or is it covered by general state law?
Mr. Justice Black, the matter of filling the jury roll and filling the jury box is governed by a special statute in Talladega County. But the general law in Alabama still applies as far as the selection of the members of the panel of the binary is concerned.
Well, you have a capital case. Let's say you have a capital case.
Yes,
in
sir.
Talladega. How many jurors do you have to have there for the parties to be struck from and under your law?
The judge is required to, normally he has a binary of, say, 50 or 60, and then he's required to draw up to 100.
There is a minimum, is there not, in the statute? I thought
That's right, that's
What
correct.
is the minimum?
100 on
100.
a capital case.
You have to have 100 jurors.
Yes, sir.
What's the object of that statute?
I don't know what the object is. It's been traditional from way back. You know, when you were practicing law down there, it was...
I suppose the object was to give both parties a chance to strike a lot of people so that
That's
they
right.
can come as near getting a fair jury as possible.
Well, of course, we have a lot of people that come in who are exempt for various reasons. We have almost 30 different categories of people who are exempt from jury duty.
Well, that wasn't the point. How many did you get to strike from in a civil case?
In a civil case,
Yes.
normally about 40, 30 or 40. Of course, in a civil case, you strike 1 for 1.
1 for 1
Right.
out of 24 men, as a rule. As I
Yes.
understand it. That's because that's a civil case, not
Yes.
of great importance. How many do you have to have in order to strike in connection with a felony that's not a capital case?
Well, they usually have 40 to 50. There's no particular set number. Now,
Well, you did.
there
what I'm
was a
trying
point
to
that was asked
what I'm trying to
here.
get at is,
Yes.
if you do not have a statute there which relates to capital cases only, which was passed for the express purpose, trying to see that there are enough men there so that when you get through striking, they could come as near as possible to getting a fair jury.
Well, now, here's been my experience with that particular thing. Sometimes we run out of a number of people. A lot of them have asked to be excused for various reasons. Some of them don't believe in capital punishment. Some of them...
I understand that, but is there not a minimum in capital cases that you have to have? If that's the statute.
Not that I know of, no,
You
sir.
don't know that.
No, sir.
Well, there's a larger number, though, that you have to have.
Well, what normally happens in a case, and it's been my experience, and I've tried them in various places in Alabama, is when you run down to, say, about 40, then the judge goes out and has the sheriff summons people from around the courthouse
That's
and
right.
from around the
But you
business.
do need to start with more jurors in a capital case than in other cases.
Yes, sir. Yes, sir.
I thought you said you started with a minimum of 100.
Well, that's what they normally summons, yes, sir. They start with 100. But a lot of them come in and say, we don't want to serve, we are overage, we are railroad engineers, we are conductors on trains, we are telegraph operators, we are teachers, we are doctors, and
Well, the judge excuses all those.
yes,
They show that they come within the statute.
and some of them hard of hearing and so forth.
Then if he gets down below what the statute says he has to have, to give him a right to strike, he sends out and gets what you call tailsman.
Tableston, yes, sir.
Goes out and summons them and brings them in.
Yes, sir.
Sure.
That's right.
That's the system you have here is that the defendant gets 2 strikes, the other party is 1.
In criminal cases,
In the civil cases, it's 1 and 1.
yes, sir.
That some of this legislation was peculiar to Talladega County. I'm looking at the petitioner's brief in the appendix. They have the many statutory provisions. Is it on the top of 8A that the special legislation begins, which is peculiar to this county, and goes all the way through 11A?
You're talking about it in the appendix?
Appendix to the petitioner's brief.
Yes.
There are set out the various constitutional provisions and Alabama statutes, and most of them seem to be of general application, and I'm asking whether the ones of exclusive application to this county begin at the top of 8A and end at 11A, just for
That's
my
correct.
information. Is that it?
Yes.
Paul, can you explain to us why it was that your Supreme Court pointed out that the Commission
Well, now, I think the commissioners did the best they could under the circumstances to Yes. I didn't understand the Alabama Supreme Court to say that. Well, you might be right. Well, now, I want to be practical about this thing. I think it's impossible for any jury commission to go out and get every male citizen between 21 and 65, whether he's white or whether he's Negro. It's impossible to do it. They go out and do the best they can with the facilities that are available to them.
The commissioner in saying that he didn't know any Negroes and therefore he did not put any on the panel.
Well, I think you will find by reading this record here that they made a determined effort
No,
by going.
I didn't say that. I asked you that question. I asked you if that would justify a commissioner in saying, well, I didn't know any Negroes, so I didn't know whether there were any qualified or not, so I didn't put any Negroes on the panel.
Well, now that's a hypothetical question.
Pardon?
I say I think that's a hypothetical question.
It is a hypothetical question.
Yes.
Could they do that?
I'm not going to say whether they could or couldn't do it, but I'm talking about this particular case, Mr. Chief Justice.
Well, didn't one of the commissioners say what was almost tantamount to what I've said?
Well, he might have said it, but the other said that they went out into the plants, they looked over the voter registration list, they contacted plant managers, which hired both Negroes and whites. They contacted the various farm organizations that Negroes and whites belong to.
Well, did they? Wasn't there one who said that he did not go to any of the
Well, you're going to blame the whole thing on just one man?
And didn't go to any of the Negro clubs or organizations, but he did go to the whites?
He didn't say he went to white organizations.
I understood that he did.
Well, he said he didn't know of any Negro organizations. Now, let's put it that way.
Or churches?
That's right.
Didn't know of any Negro churches.
Well, he might have known of some Negro churches. That may have been one man, but there are three members of the jury commission, you know.
Yes, I know, but one apple can spoil a box, you know, too.
Well, that's true. Yes.
Yes, sir. Yes, sir, I understand you. Now, that same thing would apply to white people. Well, I think you'll find that Talladega County is in much better shape than some of the other counties in Alabama as far as that particular situation is concerned. Well, I'm not going to make any admissions, but I know that there are some counties that we've been trying to work on to try to get them to improve the situation down there. And so that cases like this won't come up here. And I've been one of those that has been really working on that particular situation. But I feel like Talladega County is in much better shape than most of all the rest of the counties except Jefferson County. Jefferson County is in good shape. Butler County is in better shape than it was. Mobile County is in good shape. Baldwin County is in good shape. There were 2 Negroes that served on the grand jury that indicted this man. Well, now, I can't be responsible for that. Now, if you were either defending or prosecuting the case, you would use your own judgment as to whom you were going to strike off, wouldn't you? And you wouldn't ask anybody's opinion about it, would you? We've had some served down in Butler County, in Greenville, Alabama, recently.
Well, let's take this county. As far as you know, and as far as any of the witnesses in this case knew, has there ever been a Negro sit on a jury in this county in either a civil or a criminal case?
On a petty jury?
Petty jury, yes, sir.
Not that I know of. The record doesn't show it.
The record shows to the contrary that there has not been
correct.
any.
That's correct.
There's been some on the panel. Is that right? On the jury panel before.
They've been on the Benari, yes, sir.
Why hasn't there, over the years, been a Negro on a petty jury?
I've never tried a case in that county. I don't know.
You have no idea then?
But I have a very good idea
Why,
from
in
my
every
own
case,
experience
never-
in trying
every-
cases in Virginia and the District of Columbia now in Alabama. And representing Negroes, I would say that I have a very good idea of why.
Well, what's the reason?
Well, I've explained that in my brief. And every time I've represented one of the defendants, he said, I don't want a Negro sitting on a jury trying me.
Oh, I know, but in this case, and in lots of other cases, it's the solicitor who strikes the Negroes. Why do you suppose the solicitor strikes the Negroes in every single case? There isn't a
I haven't
validity.
discussed that with the solicitor. I don't have any idea.
Just the use of his peremptory challenge.
He doesn't have to assign a reason, does he, Mr. Justice Clark?
What about the grand jury?
Well, as far as the grand jury is concerned, the judge pulls the names out of the hat. He doesn't even look at them. There's no distinction as far as the color of the cards, the texture of the cards. There's no mark on the cards or anything. He starts pulling them out until he gets 18 men.
Where'd you get the card?
Gets the cards out of the jury box. The jury box is locked up until it's brought into the
Do
courtroom.
you have a sort of wheel?
No, we don't have a wheel. We've got a box, kind of like a safe deposit box, a steel box. It's kept locked up in the probate judge's office.
How the cards get in the box?
They come off the jury roll.
The clerk makes them up?
In this particular county, and every county in Alabama, the circuit clerk is automatically the clerk of the jury commission. And he or she operates under the directions of the jury commission. In Jefferson County, they have a full-time clerk. And
What about this county?
In this county, the second clerk acts as the clerk of the jury.
You have 3 commissioners.
You have 3 commissioners appointed by the governor.
They select the ones that go in the box with cards.
They go out and try to find the names of qualified men to go on the jury roll first. And then after they go on the jury roll, the jury box is made up from the names on the jury roll.
You're familiar with Cassell, a case down in Texas?
Yes, sir.
Is it similar to that procedure?
Well, now, I can explain it to you a little bit more in detail. They've got a great big book, and they put down the names by precincts in the various areas of the county. And then they take those names off and put them on cards, and put those cards in a box, and the box is locked up. Once those names are drawn out, they're not used again for 2 more years. And those names are separated from the other names that are in the jury box.
How many names you put in the box?
Well, it depends on how many names are on the roll. They put every one of the names that are on the roll.
They run down a road,
Yes,
line by line.
Yes, sir. That's
I thought
correct.
you said they went around the county and sort of like the cell.
They do, in making up the roll, but they make up the roll every 2 years.
Oh. They make up the roll, too.
Yes, sir. They make up the roll, and then the cards come off of the roll. So?
Color designated on the card.
Not now. There was a time back during the Scottsboro cases when it was. And even some of the counties up until recently, until the Alabama Attorney General's office got after them about that thing, when they stopped doing it. But they don't do it anymore, as far as I know.
Excuse me. Go ahead.
What do you say about the percentage?
Are you talking about in Talladega County?
Reference to the grand jury. I'm not talking about the what about the evidence in connection with the sufficiency of
Well, now,
colored people's names in the whole jury box?
the solicitor attempted to go into that and explain why there weren't more Negroes' names on the roll, and consequently in the box. And he went into some things that I don't particularly condone as far as incidents of sexual diseases and illegitimacy and things of that sort of concern. But that is in the record. I have to admit it's in there.
What about the educational?
Well, the educational qualifications have a whole lot to do with Mr. Justice Black.
In that county, how about what's the ratio to the?
Well, I don't know whether this record shows it or not, but you'll find it almost in every county in Alabama, the ratio of dropouts, from those starting in the first grade who finish in the 12th grade, as compared with the whites, about 90% of the whites finish and about 50% of the Negroes finish.
Are there many of the local Negroes that go to the Talladega College, take advantage of that?
Not very many. They come from other parts of the state.
You have good schools in Talladega.
Very good schools, yes, sir. Very good schools in Tuskegee.
And it's a compulsory education there.
Yes, sir.
Is it enforced?
But a lot of those that get the education, and we find this true almost in all these rural areas of Alabama, those that do get the education leave. They don't stay. They go north. They go to Detroit, New York, and Chicago, and various other places. So that it leaves the old people, the ones that either are illiterate or infirm or too old or something of that sort. So we don't have too many left other than school teachers. And school teachers invariably claim the exemption. And of course, most of the school teachers are women, and they're not liable for jury service.
What did your commissioner say about knowing the colored people in this county?
Well, they all know, practically all of them in rural counties.
Did they testify? Commissioners testified?
2 of them did. I think maybe all 3 of them did. I'm not sure about that. All testified.
You have a statutory test I'm reading now from the bottom of 4A and the top of 5A of the appendix to the petitioner's brief, which requires that in order to be eligible for jury duty, a man must be over 21, and then he has to be generally reputed to be honest and intelligent and esteemed in the community for his integrity, good character, and sound judgment. I suppose it's not only a matter of perhaps white jury commissioners not being acquainted with Negroes, but perhaps also a matter that because of 75 years or more of thought patterns and social customs down there perhaps would be fewer Negroes who would have that general reputation in the community at large for those qualities than there would be white men. Is that right?
No doubt about it, because a lot of them are guilty of various disqualifying crimes. Of course, that's true of a lot of white people, too, but you find the percentage is larger among the Negro population than you do among the white population.
Certainly their general repute for
yes.
qualities of honest, intelligent, esteemed in the
I'm
community.
not trying to cast any aspersion upon the
I'm asking, as a matter of fact, whether or not the jury commissioners whether there would be as many, proportionately, as many Negroes who had this estimation of the community at large, as there would be white
I don't
people.
think so.
You say there were 2 on this grand jury. Is that true?
There were 2 on this grand jury that indicted this man for rape of a white woman.
Are there some on all the grand juries, or do you know statistically?
So,
You know the statistics on whether or not there's some on each of the grand juries.
well, there have been some on quite a few grand juries. There have been some grand juries that haven't had Negroes on them.
So
But there wasn't any particular reason why they happened to be on this grand jury. They just, that's the way the ball bounced.
Commissioners don't put a certain percentage of...
They don't put anybody on the grand jury. The judge pulls the names of the...
No, I mean on the roll. They don't put a certain percentage on the roll of Negroes. Is that right or not?
They don't make any effort to do that, no, sir.
Just comes out a certain percent.
That's right.
Mr. Hall, is the same striking procedure used statewide? You start out with a number of jurors, and then there's the alternate strike until
Yes.
you get your jury.
Yes.
That's statewide.
Yes.
And does striking have to stop when you get to 12?
That's right. And, of course, if
You can't go on striking and force the calling of more jurors.
when you get down to 12, that's your jury.
That's the end of it.
Yes, sir.
No more strikes to either side.
That's right. Of course, you've got your challenges for cause first.
Oh, I understand that.
12 that have been left in the box.
Yes.
But it happens if you don't have enough jurors.
Then you can go out and get some talisman. That's right. Get them from the area around the courthouse. That's the way they usually do it, you know.
Well, now, the question that the evidence in this case is that the prosecutor usually asks the defense counsel if he wants Negroes on the jury. That was the testimony here in this case.
There's some testimony to that effect, yes, sir.
And but that question wasn't asked in this case.
Whether it was asked in this particular case, the record doesn't show, as far as I know.
But you agree that all the strikes in this case were made by of Negroes were made by the prosecution?
It's possible. But
Well, is it? Can you tell from the record or can't?
well, if I were the prosecutor, I'd probably do the same thing.
Well, I know, but I just wondered, as a matter of fact, on this record, does it show that the Negroes who were stricken by the prosecution? Is that
I don't know whether the record shows that or not. It does.
Please.
I think, Mr. Justice Clark, if you would look at Section 63 of Title, I don't have it here, I'm referring to the Alabama Code, Title 30, Section 63. I thought perhaps we had cited in our brief somewhere, but that's the statute I believe you have in mind, which sets a minimum number of jurors to be called in a capital case of 50. And no more than 100. It says the circuit clerk shall direct the sheriff to summon at least 50 and no more than 100 in a capital case. I think if you look at that, that would be the section. Now,
That doesn't apply to felonies in general, does it?
no, not just capital cases. There's a separate section on felonies in general. Now, in this case, I think, as we mentioned previously, it's clear that the jury commissioners, whose job it was to secure names for the jury roll, which were then put in the jury box, relied on their acquaintances, business acquaintances and social acquaintances primarily in securing these names. One jury commissioner has been pointed out didn't even know the percentage of Negroes in the county. He estimated it at about 10%, where actually it's 32%, 26% being the number of Negro males over 21. So that he had no idea of the number of Negroes in the community. And then one jury commissioner on page 95 of the record, he was asked, have you gone to any purely Negro organizations for a list of names? And he said no. The jury clerk who assisted the process of getting the names said she knew a couple of Negroes. And this was the extent of anyone's direct testimony as to knowing any particular Negroes. She said, I asked Bob Strickland and Principal Mayberry to send me a list, and I asked another man, and he never sent it. And whenever a jury commissioner was asked to name some Negroes he put on the jury list, he couldn't even do it. His familiarity with Negroes was so limited.
So in an ideal world, he wouldn't be able to do it, would he? He should know, I suppose.
Well, he should have some system whereby all qualified persons, I would think, are placed on the jury roll as the statute here requires.
But he should be colorblind.
Well, yes, he shouldn't...
he shouldn't know I put so many Negroes on.
Well, he should be able to name some. If there are a large number of Negroes, as he claimed, that had been put on here, he ought to be able to call a few. Not that he could name every single one. That's right. What he should do is...
trouble, though, is you might run into trouble with Cassell if he went directly to Negroes to put them on the list deliberately.
Yes, that's right. I'm not saying he should go out and say, well, I've got 6 Negroes and I'm going to put them in the box.
He's got a pretty tough job under Cassell.
Pardon me?
Not under Cassell. He has to stay away from any lists where he deliberately select Negroes. At the same time, he must have somebody on there to show that he's not discriminating. So he's really got a pretty tough job, hasn't he?
Well, I think the best way to get around it is to have an impartial method whereby you select a large number of qualified persons. They had no systematic method for getting the names, and that was their trouble.
You suggest it would be appropriate to go to all Negro organizations, to and all one
well,
or all
if
Negro
that's their
organizations.
method of getting it, if that's the method, is to get names from organizations only, then I say they should go to Negro and white organizations, if this is your method.
I see.
But they didn't have that method particularly. They sometimes went to the jury, to the telephone book, sometimes the city directory, and so forth. They failed to have any system for getting these names, and that led them into trouble. I think my...
designations at all. Just took some out of each page. Think that'd be bad?
No, whatever method they use, if they used it as the method, and that method was used on Negroes and whites alike, of course, that would be all right.
You claimed then that the Negroes didn't have a telephone, wouldn't you?
Well, if that were a fact that they knew, if that happened to be the fact in that community, that they knew this, and this was a method which they used to get whites only. I believe my time is up.